Your Honor, may I address the court, please?
Oh, I have a publication, sir. I'll address you just a moment. All right. This is docket 26850FH, People of the State of Michigan versus LaPrece Tyron Evans. Counsel, your appearances for the record.
Good afternoon, Your Honor. A.K. Buxton on behalf of the people of the state of Michigan.
Good afternoon, Assistant Public Defender Sarah Dowling on behalf of the defendant who stands to my right.
Sir, please raise your right hand. Do you swear or affirm testimony you're about to provide be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
Thank you. Put your hand up. Have you taken any medication yesterday or today?
No, I don't take medication.
Are you supposed to be on medication? You're
No,
not
I
on?
don't take medication.
Wait, are you supposed to be on medication?
You're not on.
What's the
I
answer?
don't take medication.
Any sign of fever, cold, or other illness?
No.
And have you spoken to your attorney?
It wasn't a good conversation. We had just a few minute conversation and she got mad and ran out.
Okay, so it appears the two of you are not getting along?
Yes, no, yes.
Your Honor, if I can,
She was
Just a
speaking.
moment, sir. Counsel?
yes, I just want to say that, yes, it has been a breakdown in the relationship. Just to put some context into it, I am Mr. Evans's third attorney. His first attorney, Robert Palmer, filed a competency position, and Mr. Evans eventually came back competent. But then when Mr. Palmer left the office, it was assigned to Derek Etheridge. It was assigned to me after the breakdown in the relationship happened with Public Defender Etheridge. And in my opinion, Your Honor, there is no attorney that could have a relationship with Mr. Evans. He continually tries to advise his attorney about the law and not listen. So at this point, I have told and instructed Mr. Evans that he can either represent himself or he could change his attitude and start listening to his attorney.
Objection, Your Honor.
Well, sir, you don't get to make an objection, but I will call on you. If there's a breakdown in the attorney-client relationship, that's fine, but I want to warn you about something. The public defender's office doesn't generally give 3 attorneys. They did in this situation. Now, Mr. Palmer took another job, so Mr. Etheridge was assigned, so you had 2. I know they're not going to give you a 3rd. We have conflict counsel. But here's the thing. You didn't go to law school, and you don't have to listen to everything your attorneys say, I suppose, but they're giving you legal advice based on their knowledge of the court, the law, your case, and if you don't want to follow it, that's on you. You can also choose to represent yourself, but there is not an exhausted, a list that is not going to be exhausted because you have already exhausted the public defender. We have limited on the conflict counsel, and then we're out of luck. You can represent yourself, but that's usually not a wise idea. So tell me about the breakdown. What is it you want me to know?
Well, Your Honor, with Mr., are you talking about from the beginning?
No, just with Ms.
With
Donnelly,
Ms.
'cause
Donnelly.
I don't care about the rest. We've already made a record of
Okay,
those.
I wrote you a letter. Did you get that letter in the prosecuting attorney? I
Okay,
have a copy of that.
I need to make a record of this, sir. What is it you want me to know?
It's in the letter, but I'll let you know right here
Do
that
you want me
I
to
filed
find
a
the
motion.
letter and read it in? I suppose I could do
Yes,
that.
yes, I would like you to do that, ma'am. Was that because
See if I
tell us
can-
about the breakdown, the things that happened, why it happened? Basically, I was telling Mrs. O'Donnell that I wanted her to have a motion for dismissal because I've been locked up
Denied.
for over 180 days.
Denied. I'm denying it. That's
Why?
not a,
Why is that?
sir, 180 days is.
That's my constitutional right, man. Constitutional right.
I know all about that, sir.
6.004
Mhm,
states
mhm.
that after 180 days, I have a right, I'm entitled to a personal counsel bond and dismissal of the charge.
Except on certain conditions, such as your criminal history, and we
I've-
have here an assault with intent to great bodily harm less than murder, or strangulation is a 10-year felony.
Yes, and that is not part of the, I've read that. So I've read section 6.004. So I
Public
do not follow
safety,
up on that.
public safety is at issue. I can go past 180 days for good cause, for public safety, for safety of the victim, based on your criminal history. There are a lot of reasons I can go past 180 days. Otherwise, we'd have a whole lot of people causing delay. And some of the delays were attributable to you, not the people, so I don't even know if it's 180 days because the delays were on you for getting different counsels, so I don't know how you calculated
The
all
first,
that.
excuse me, ma'am, but the first council switch was not because of me. The second one, I fired Mr. LaPrece because he's trying to tell me that the 180-day rule did not exist. It only existed for, people, and I've read the whole issue with that, so I know that he was lying to me, providing false information. So that's why I ended up with Mrs. O'Donnell. And once, on this motion that I filed on 6/12, I had her file, and she comes and tells me, as soon as I got to talking about the 180-day rule, she gets up, gets mad, slams it like it's in this letter, and runs out.
Okay,
So I wasn't able to tell her to file the motion for dismissal for the 180.
well, you can't tell her to file something, I mean, she can file if she wants, but she knows that I'm gonna deny it. And one of the other reasons, which you need to read the rules and have some training on this, 180 days is not an automatic out of jail. You have criminal history here, and you have failed to appear on 2 or more prior qualifying entries. And so your failure to appear.
That's a lie, man. That is not true. I don't have any failure to appears. I went to every court date. I was not given for the competency hearing. I was not even given, I didn't have even knowledge of that.
You didn't have knowledge of that,
I
well,
did
you
not have
underwent
knowledge
it,
of it.
you underwent it.
This is after I got locked up, man.
Oh.
On December 10th, I did not have knowledge of that I was supposed to have one on December 1st. I did not have knowledge of it. Judge Simmons wasn't even in the courtroom on December 11th, but I got locked up anyway, for no just cause.
Okay. Well,
There's a lot going on, you have to listen to me, you got to understand what's really going on. You can't just sit here and hear like 1 minute of what I got to say and then expect to have any clarity of it.
sir,
There is a lot going on there.
on behalf of the people, have you calculated the days, first of all?
Yes, I have 2
Not you, I said on behalf of the people.
Your Honor, this is the first time I'm receiving this motion. I did not realize there was a 180-day issue that the defense was bringing at this point in time. I have not calculated it. However, it is my understanding that, one, there was the forensic, and a case does pause for the forensic evaluation. 2, Your Honor, it is my understanding that he was found in contempt of court on multiple times in front of Judge Simmons, which resulted in 93-day arrest, which, to my understanding, would not go to his 180-day rule either. Your
Objection,
Honor.
Your Honor, that was done out of fraud of the court.
How we're gonna handle this, you interrupt counsel, I'm gonna start imposing 93 days. And let me just tell you, contempt does not go against 180 days. When you're in the forensic center, it does not go against the 180
I
days.
was not in the
Switching
forensic center.
93 days. Bye. I'll see you in 93 days.
I wasn't in the forensic center.
Bye.